presentation on tenant protection plans. New York City has a well-documented history of tenant harassment. Typical methods that historically have been employed to empty buildings of tenants range from failure to provide essential services, to pest infestations, to failure to maintain public areas, elevators, appliances, etc., to performing soft demolition without a permit and envelope deterioration, to more extreme versions such as arson. Arson was rampant in the 1970s. In 1976 alone, there were more than 13,000 fires that were set. Documentaries such as The Boxes Burning and The Decade of Fire depict this era. The headlines you can see on your screen are more recent examples of tenant harassment. In both of these cases, the New York State Attorney General commenced litigation against property owners in the Lower East Side. The allegations enumerated in the complaints include construction as harassment, where tenants allege that owners engaged in deliberate practices to push out the rent-regulated tenants by engaging in unsafe work practices. The state prevailed in both of the cases. In response, over the past 8 decades, the city and state has steadily adopted practices to protect tenants, establishing civil court and landlord-tenant court hearings. In the 1940s, rent control was adopted. In the 1970s, its successor program, rent stabilization, was implemented. Both rent control and rent stabilization are two distinct sets of rent regulation designed to guarantee lease renewals for lease-abiding tenants and to limit rent increases on an annual basis. In the 1970s, the warranty of habitability was also introduced, guaranteeing safe, habitable living conditions for all New Yorkers. In the 1980s, the mayor's arson strike force was implemented, responding to obviously the decade of fire of the 1970s and the first introduction of the DOB Tenant Safety Plan, which was a precursor to what we know now as a Tenant Protection Plan. The DOB Tenant Protection Plan was codified in the 2008 New York City Building Code and includes the 7 essential elements of a TPP that we'll discuss here today, namely egress, fire safety, health requirements, housing standards compliance, structural safety, noise restrictions, and essential services maintenance. Apology. Okay, finally, the final point that was adopted was in 2017, and in 2019, the City Council adopted what is now known collectively as the Tenant Protection Legislation. The Tenant Protection Legislation is a series of 25 laws that were adopted between 2017 and in 2019 that were designed to protect tenants who are living in occupied buildings. While I'm not going to individually talk about each of the laws, I'm showing them here today so you can see the context of all of the laws that were passed between 2017 and 2019. Those that are highlighted in dark blue are those that we'll specifically reference today and that refer or relate to tenant protection plans. So you'll see here in 2017, of the approximate 11 laws that were passed, we have 2 laws that were directly related to tenant protection plans, namely Local Law 154, which kind of set the standards and the perform and inspection requirements for TPPs, and Local Law 161, which actually created the Office of the Tenant Advocate. Moving on to 2019, you have additional laws that were set, namely Local Law 106, which was brought about at the request of the industry for the obligation to file the TPP. And then moving on, there's an additional 3 laws that we'll discuss here today, which include Local Law 114, Local Law 116, and Local Law 118, all of which relate or enhance the protections that are provided to tenants within a tenant protection plan. Local Law 161 of 2017 established the Office of the Tenant Advocate. We're a fairly new office. We're set up to handle complaints and act as a resource for tenants who live in buildings that are under construction. Our phone number is posted on the website. Tenants email us directly at tenantadvocate@buildings.nyc. and we respond directly to complaints or concerns that tenants raise and pose in a building under construction. Specifically, Local Law 161 requires that the Office of the Tenant Advocate monitor TPPs to ensure compliance with the Administrative Code, that we establish a system to receive comments, questions, and complaints with respect to TPPs, and that we communicate directly with tenants who are affected by work and occupied multiple dwellings to ensure that they have notice of such work, they understand the TPP and the requirements and their rights during construction. And finally, we monitor sites with tenant protection plans to ensure compliance and, if appropriate, make a recommendation to the commissioner to issue a stop work order until such site is in compliance. The Office of the Tenant Advocate works very closely with the Office of the Building Marshal. You'll hear from Sal Agostino at the end of this presentation, where the Office of the Building Marshal carries out the inspections that are requested by OTA, among other items. I'm going to turn the floor over now to David Hendershot, who's going to talk about the 7 essential items of the TPP.
Hi, everybody. I apologize. I just wanted to back up for a couple of minutes to go through a few more of the required statements that we have for the continuing education program. You can see here, this is the name of the course, and you'll be getting your certification later on. So there's copyrighted materials protected by copyright laws, and we are an AIA provider, so it's a program that's registered with the AIA for continued professional education, and it's been reviewed and approved by AIA. So learners have to complete the entire program to receive the credit, and continuing education learning units earned upon completion of the course will be reported to the AIA for AIA members. And certificates of completion for both AIA and non-AIA members are available on request. Just going back to the purpose of the course, it's going to be reviewing the regulations of the construction codes. Tenant protection plans are one element of a comprehensive integrated approach to tenant safety. Each TPP has to provide the means and methods employed to assure compliance with the law's provisions. This course is going to outline specific TPP elements to be addressed, enumerate responsibilities of various parties, and to discuss enforcement. So the learning objectives specifically to be able to explain when a TPP is required, who has to file it, who must sign the attestation. We're going to review the 7 essential elements, which Sarah has already mentioned, and describe the level of detail and site specificity that's required. We're going to discuss recent changes required by the new local laws impacting TPP content and procedures, and then we'll identify the best practices with respect to TPPs. So I'll rush forward to my own part of this and apologize again. I'm concentrating on the actual TPP documentation, which is primarily related to the 4 local laws that you see on your screen now. The basic law is Local Law 106, which gives you the protection plan and related requirements. And it also tells you that drawing statement is required that a TPP will be submitted prior to permit. Local Law 114 relates to the tenant protection plan production in that making false statements about building occupancy status is going to be subject to hefty fines, and any work without a permit, pretty much the same. Local Law 116 of 2019 is going to have miscellaneous amendments, which are partially included in the next law, 118, which is the one that I'm concentrating on today because it's relatively short amendment that includes most of the provisions that you're going to be required to have when you submit the actual document. I've chosen to show the actual text of the local law 118 in order to make everyone realize that the purpose of the compliance is based upon the law and not upon any necessarily other guidance that you may receive from sources. This is where the interpretation occurs. You can see here where the word shall appears, which is sometimes controversial, but it shall mean must. In general, you have to provide a tenant protection plan whenever there's an alteration, construction, or partial demolition of buildings in which any dwelling unit will be occupied. And as of a recent change, which we'll discuss later, the registered design professional preparing the tenant protection plan is going to be retained by the general contractor. It's no longer the applicant of record, with a few exceptions. And no permit can be issued for work that requires a tenant protection plan unless that plan is approved by the department. This is another recent change where we previously had required the TPP1 tenant protection plan to be submitted at the time of approval. It's now required prior to permit. Another recent change is that there's going to be a statement signed by the owner and the applicant that the building contains dwelling units that are going to be occupied, and that you have to identify in sufficient detail the specific units that are there. And I've underlined the term means and methods because that's important in terms of the discussions that we've had with the industry and these changes, because means and methods are normally something that's not handled by the applicant of record for the construction, but rather by the contractor. You can see my note at the bottom, which is just saying that the text of the law is in black. I've added a few notes in orange and I've underlined some things as well that I'm trying to emphasize here. Moving along, you're going to have to put in details of the presentation for things such as temporary fire-rated assemblies, opening protectives, dust containment procedures. One of the things that we are being focused on now in particular is that you not use generic language like code compliant, approved, legal, protected in accordance with law, or such things. You really have to be specific in the way that you describe exactly what you're proposing for that specific job. And again, at the very end of this paragraph, I've indicated you shall make detailed and specific provisions for the following, which are the 7 essential elements that are mentioned previously and also in the learning objectives. The first one is egress. The tenant protection plan has to identify the egress that's going to be provided. You can see by my question in orange down below, how do you think you'd adequately identify egress without having a floor plan diagram? I think that there are some cases where that would be possible if, for example, you had a large building and you were just renovating one apartment and you weren't changing any of the egress and you weren't affecting any of the public hallways or anything like that, then you might be able to provide a verbal description that the existing egress was going to remain, and this is how you're going to make sure that things are kept clean, things are basically kept in order to avoid having to show people something different about their usual way of going through the building. The fire safety aspects, you're going to have to make sure that you're complying with everything that's relevant to protecting and maintaining fire ratings of all of the existing spaces, as well as clear means of egress. The third one, health requirements. You're going to have to tell us specifically how to control the dust, how you're going to be getting rid of construction debris, how you're dealing with vermin, how you're dealing with maintenance of sanitary facilities. Another issue relates to lead and asbestos, toxic materials that could be exposed during the course of construction. And we want to make sure that there's a statement that describes exactly how you're dealing with those sort of things. For example, if you're doing an asbestos inspection in an older building, you might say that the asbestos inspection has been performed, nothing is found, ACP5 form, what's been obtained. But if, for example, you are going to be removing asbestos, then you've got to make sure that you describe how that's happening. Health requirements, we just covered. Compliance with housing standards. There are certain requirements within the Housing Maintenance Code and the Multiple Dwelling Code that you have to comply with. In general, habitability standards are not relaxed during construction. Going into a little bit more detail, the Housing Maintenance Code itself has about 140 pages, but there are aspects of it that relate specifically to construction activities like cleaning, painting of public spaces. And there's also the inclusion of the Safe Construction Bill of Rights, which is something that Salvatore will be talking about later on. As for the multiple dwelling law, it's about 160 pages, but some examples there would be prohibited uses such as storage of hazardous materials and that sort of thing. And also in Article 3 of the multiple dwelling law, you've got some general provisions such as water supply, heating, cleanliness. Item 5, structural safety, and essentially that's the registered design professional's judgment based on your thorough knowledge of the scope and in conjunction with the contractor to make sure that there's not anything that's being done that might put anybody in a hazardous situation. Noise restrictions, there's a New York City noise ordinance, which is about 25 pages. That's a DEP produced document and it's their jurisdiction in general, but nevertheless, the tenant protection plan needs to specify the means and methods for limiting the noise. And if you're going to be working off hours, then you have to get an off hours permit, state such things. Basically, exactly how is the noise being mitigated, exactly when is work going to take place. Maintaining essential services is pretty straightforward. If you've got heat, hot water, cold water, gas, electricity, all these utility services have to be maintained during the course of construction, and you have to state that specifically. Always means and methods, never just replicating the words of the code, but rather answering what the code requirements are. There are a couple of exceptions to the contractor required tenant protection plan. If you're working in a 1 or 2 family home, or if it's limited to the interior of a single dwelling unit of an occupied multiple dwelling with no disruption to the essential services of the other units and it's owner occupied, then the registered design professional or the applicant of record for the actual construction job can submit the tenant protection. There, just mentioned in passing, another enforcement issue that Salvatore will be mentioning later, but part of local law 118 provides for $10,000 minimum fine for not providing a tenant protection plan or for providing one that's considered not to be sufficient for the scope. There are a couple of different places where that has been added to the text. Up next, in order to explain the law, the DOB put out this service notice in May of 2020, which explains the changes that were recently made to the TPP1 form that you submit to the Department of Buildings. You're going to need to identify the apartment units that are going to remain occupied, identify the specific means and methods of noise, and it's a little bit small at the bottom of this page, but you're going to have to put a note on the drawing, the title sheet of the construction documents for alteration, construction, or partial demolition work, that the tenant protection plan will be submitted in accordance with the requirements prior to issuance of the permit. This is the revised TPP1 form itself. Section 1, simply location information, and it says specific unit apartment numbers to remain occupied. And despite the fact that it may be a large building, you do need to list all of those separately and not just say all units or everything on the first floor, whatever. The next item, tenant protection plan, essentially reiterates what we just talked about. There's a slight difference in the language here, clarify versus identify. I'll leave that up to interpretation, but in general, just want to make sure that adequate egress is going to be maintained. Again, these are the 7 things that we've talked about already. And then below that is a blank space where you'll be answering these questions. Item 3, going back to something we were talking about before, it's possible for you to add some attachments to the TPP1 form. That could be AI1 forms that you need in order to add additional text beyond what's on the TPP1 form itself, or it could be a floor plan diagram or diagrams. For example, if you have phased construction of a multi-floor building, or where you're going to be blocking egress in one part of the building and then blocking egress in another part of the building, you're going to want to provide some sort of phasing plans to direct people to different parts of the building at different times during construction. So again, the registered design professional is responsible for determining the diagram requirements. There's an owner statement that we talked about earlier, signed and sealed by the applicant as well. And at this point, I'll transition over to Salvatore Agostino, who's going to be talking about the enforcement issues. This shown here is just a sample tenant protection plan, which is a kind of a placeholder for you to ponder what you believe would be possible drawing requirements for the plan that you produce. Thanks.
Good afternoon, everyone. My name is Salvatore Agostino, Buildings Marshal for the Department of Buildings. I'm going to walk you through the rest of the presentation, mainly focusing on enforcement. I want to start off with tenant protection plan versus the occupant protection plan. The easiest way to differentiate between these two is the tenant protection plan is required only for residential buildings or a mixed-use building with residential units. The occupant protection plan is required when work is ongoing inside of a commercial building. If the commercial building is mixed use, has any residential units, it may be a requirement for a TPP. We received some questions about the difference between the two and overlap. The occupant protection plan must be available on site for review. If an inspector were to conduct an inspection or to receive a complaint, the OPP is not filed with the department. If there is an issue at the site and there's a stop work order or a complicated issue that may raise an objection, the occupant protection plan may be requested. So the OPP has to be on site for review by DOB personnel, but it is not filed. The tenant protection plan is filed with every job containing a residential unit. If the scope of the work is specific to the commercial area of the building, but there are residential units within the building, the tenant protection plan is still required. Local Law 154 of 2017 was really the first local law that had sweeping changes and brought us into the new era of focus on tenant protection plans. Local Law 154 mandates that owners of occupied buildings, residential buildings, are responsible for distributing and posting the tenant protection notice in the lobby on each floor. Now, this is a notice that there is a tenant protection plan. It is not the actual tenant protection plan. So the notice to the tenants that a TPP exists must be posted. The original version of 154 has been modified. The TPP can no longer contain generalized terms about being code compliant, legal, or approved. The terms must be specific, and the tenant protection plan must be specific to the scope of work and the characteristics of the job. The TPP must specify the means and methods for maintaining essential services, all essential services. If there's a disruption, a time frame for the disruption, and the means and methods to be employed to minimize the disruption. So what we mean by that is that the tenant protection plan must provide instructions to the contractor as to how to ensure safety, not just a general statement that safety will be maintained. It must have specifics. The Department of Buildings is responsible for making the TPP available on our website. The owner is responsible for having the TPP available for distribution upon request by any tenant. Owners are required to post and distribute the notice of the tenant protection plan. It must be in the lobby and on each floor. The notice must state that the TPP is available for distribution upon request by the tenant. Tenants can make that request in person, by email, in writing, a phone call. Any request needs to be honored by the owner to provide the actual physical tenant protection plan to the tenants. The tenant protection plan can be provided on a paper form, or if the request is made via email, it can be emailed. On this tenant protection plan and on the notice, it must contain the name and contact information for the licensed safety professional, whether that's a site safety manager, site safety coordinator, or construction super. There must also contain a statement identifying 311 is the proper channel to report any complaints about work in the building. Local Law 154 also required owners to notify the Department of Buildings at least 72 hours prior to the commencement of any work requiring a tenant protection plan. The form required to provide notice is available on our website. DOB randomly audits 10% of the work sites for compliance within 7 days of receiving the notice. There's been a number of bulletins and service notices that have gone out about Local Law 154 and the other local laws regarding tenant safety. DOB has created the notification form, which is a web-based form that can be used to notify the agency of commencement of work. Again, that has to be within 72 hours. And the TPP notice template, which is available on our website, must be used. You have to use the version of the template that's been approved by the agency. It's uniform, and it has all of the proper items and requirements on it. If you do have a TPP notice that does not comply with the template that we have on our website, it does not satisfy the requirement. Again, the notice it should be printed out in color, so it is in red, so it catches the attention of the tenant. It has all the required items on the notice, and you must use the prescribed template. If you have a different notice up, it will lead to a violation. Local Law 159 of 2017, the Safe Construction Bill of Rights. This is also a notice that must be posted. It must include the description of work being conducted and the locations in the multiple dwelling where the work will take place. Must include the hours of the construction work, a projected timeline for the completion of work, and a description of the amenities or essential services anticipated to be unavailable or interrupted during the work, and how the owner will minimize the interruption. Must also contain contact information, a phone number, or an agent or employee of the owner who can be reached for non-emergency matters pertaining to the work being performed. And also contact information for emergency matters pertaining to the work being performed 24 hours a day, 7 days a week during the duration of construction. The Safe Construction Bill of Rights must be distributed and posted in the building lobby, as well as within 10 feet of every elevator bank or main stairwell in the building. Notices must be in English, Spanish, or any other language as prescribed by rule. The Bill of Rights and the TPP notices must remain posted until the completion of the work. The contractor and the owner are responsible for ensuring that the notices are posted and maintained. These notices may be taken down or may fall down by accident. You're required to keep these posted. Notices must also provide contact information for the relevant city and state agencies where occupants, tenants, may submit complaints or ask questions regarding the work being performed. And there's been a number of service notices and bulletins, outreach to the industry about this issue. HPD and DOB are both enforcing the requirement for the Safe Construction Bill of Rights. HPD does have a template, which is available on their website, that owners can use to comply with the law. This is the HPD template. Local Law 188 of 2017 created the Real-Time Enforcement Unit. That unit is specifically dedicated to responding to complaints of work without a permit in multiple dwellings. That unit responds to complaints within 12 hours. And any other complaint related to work without a permit in a multiple dwelling is responded to within 10 days of receipt of the complaint. Our response time to complaints of work without a permit in multiple dwellings is under 12 hours currently. DOB has updated its permit application to enable us to identify permits for alteration of 10% or more of existing floor area. There's also a notification form, which allows owners to notify the agency of work in an occupied multiple dwelling. If 10% or more of the existing floor area is under construction, the job falls into the criteria for notification. There is one notification form for 72-hour commencement of work and for the 10% or more existing floor area ratio. That one notification form can be used to notify the agency for both situations. That concludes our presentation. We will have a question and answer session that we will begin shortly. We've received a number of questions. We are collecting the questions, and we've answered a few people individually. If there were short questions, there are some questions that will be beneficial for everyone to hear the answers to. So we will answer them. Some of them may be answered in the QA chat box. Some of them will be answered verbally through the presentation. We're going to take a couple of minute break here just to collect the thoughts and collect some of the more pertinent questions. Thank you. Okay, thank you, everyone. So a number of questions came up again about the occupant protection plan versus the tenant protection plan. Again, if it is a mixed-use building, if there are residential units above and a commercial space below, and the work is confined to the commercial space, that project that will still require a tenant protection plan. The tenants above in the mixed-use building may be impacted by the work. If they are not, the tenant protection plan can go into detail or describe the situation as to how the tenants may or may not be affected by the work below. But if it is a residential building, or if it's a mixed-use building with any residential units in it, there is a TPP requirement. Again, there was a question that came up about prior to a TCO being issued. If there is a new building and part of the building will be partially occupied in phases, and the initial filing did not have any occupants in the building. Once that TCO is applied for and there are going to be tenants in the building and residential tenants in the building, the TPP is required. So there are different scenarios where the occupant protection plan may at some point satisfy the requirement, but then later on, as the building becomes occupied, if it's a mixed-use building, it would then need the tenant protection plan. There's a question about if listing the number of units on the TPP of occupied units and running out of space. A simple solution to that is to use a range. If units 1 through 20 are going to be occupied, you don't have to list each single one individually. You can use a range, 1-20. If you run out of space, you can attach an additional form. But every unit is required, even if it's a large building with 100 units, they all must be listed. Question about TPPs applying to the building under construction, but if the TPP could or may apply to the adjacent building. So TPPs apply to the building under construction where the application is filed. The contractor has an obligation to protect the adjacent buildings from any debris or any collateral damage. But the tenant protection plan is specific only to the building under construction for which the permit and application is filed. It does not apply to neighboring buildings.
Hi, it's David Hendershot here. I'm going to answer a few more of these other questions. One of them was regarding a TPP for privately owned single-family or two-family detached residence on an individual lot. And it really doesn't matter what sort of occupied dwelling it is, as long as it's an occupied dwelling, one family, two-family, multifamily, it still requires a TPP. Again, some of the questions about space on the form itself, if you don't have enough room to do something, simply add a form. We're scrolling through the chat as we speak here, so if you don't mind having a few pauses now and then, we'll continue going. There's quite a lot of information to try to go through at the moment. We'll reemphasize that the TPP itself is not applied to commercial properties. TPP notes were on the drawings previously, but now that it's gone to prior to permit, you will not be putting TPP notes on the construction drawings. You'll simply be putting that note on the first page where you're saying that a TPP is going to be filed prior to permit. There was a couple of questions about how specific boroughs are dealing with particular requirements, and it's not really possible to deal with all the boroughs since we're all working out of the Manhattan office and we don't necessarily have a fully developed knowledge of how this is being implemented. You've probably noticed that there's no specific guidance from DOB on exact requirements, like giving you an example of a tenant protection plan drawing to show what's supposed to be included. And that's simply because as a registered design professional, you're really responsible for determining that information yourself. DOB's position is one of reviewing, not advising. So therefore, each individual examiner in each individual borough is really responsible for reviewing that individual plan. And so you will be getting some different answers, but we're trying very hard to make everything as consistent as possible. We're all trying to make this work as best as we can. There are also different questions about if there are multiple jobs in one building, do they need to each file their own tenant protection plans? And yes, that is true. Each contractor in a building is going to have to file their own because the circumstances of those jobs may be quite different. If a building owner is not cooperating in order for you to put a TPP together, that's not really within DOB's purview, so you'll have to resolve that externally. We require the information and you have to get it. There's a question about, is 11 by 17 the only acceptable format? I will say that that's what's on the form. I'm not sure that that's going to be sufficient for some of the larger jobs. So if you have a specific job where you believe that larger drawings would be required, I would inquire with the planning examiner and we'll get back to you on that. 11 by 17 often conflicts with the actual text requirement sizes for DOB drawing standards and that sort of thing. So there's a tenant protection plan question about whether or not an existing building receiving exterior work only is required, and the answer to that would be yes. You're working in a building with occupied units, you have to provide a tenant protection plan. We have a question asking whether or not the registered design professional for the TPP can be different from the applicant of record for filing purposes. That TPP can be uploaded with associated alt rather than filed separately. I believe that it would be acceptable either way. There are circumstances with the 1 to 2 family dwellings or with a single unit in a large building that's owner occupied where the applicant of record can submit the TPP. Typically, the law is worded so that the contractor is hiring his own registered design professional. And that may be the applicant for the main job, or it may be somebody else. Are there special TPP filing requirements for occupied public housing, multifamily buildings? I believe they're the same as they would be for any other. There are some questions about having to file PAAs for TPP1s. If you're making the changes to something that's been reviewed by DOB, then a PAA is typically required. There are certain times when a drawing only revision is acceptable without a PAA. We can follow up perhaps with that regarding whether or not that would apply to a TPP form that was submitted as part of a filing as a supplemental document or as a separately filed TPP. There's one question about who the owner is for posting purposes in a condominium where there is actually no owner per se. I will give a tentative answer that it would be the co-op board would be responsible for doing that. But if there's a difference to that, then we will add that to the Q&A at the time that this is posted on the DOB website. One person is asking how you define the owner. For the purposes of the DOB, the owner is the person who's listed as the owner on the PW1 form. Where on the DOB site are TPP plans available? If you go on the DOB website, you can download the forms. Just simply search for forms and you'll get a TPP1 form. Plans themselves, as I said, that's not something that you're going to find on the website. Those are things that you develop by yourself. Here's a question about DOB now. Currently requiring submission of TPP prior to plan approval. That depends upon when the filing was done. If you refer back to the service notice that we mentioned at the beginning of the session, you will note that it was the date of in June that the TPP requirements changed from prior to approval to prior to permit. So you'll be required to do it according to that cutoff date. We've actually approached the end of this session. It's 12:30, so in order to allow sufficient time to prepare for the next, we're going to close out. Thank you, everybody, for attending. And as I stated before, everyone, please register for any additional shows or presentations that you may be interested in. Thanks again. Have a good day.